very much. We're pleased to have a very diverse panel today who have a range of experiences in just different areas as it relates to the issue of hate speech and freedom of expression in Canada. And so my job is to kind of make sure things move fairly smoothly and to do a brief introduction for each individual panel member. I can't spend as much time introducing them all because we would be here for another hour and a half before we got to the forum. So let me just give you a brief overview of some of their accomplishments and who they are. Just in terms of moving from my immediate right and just down the panel, Professor Richard Moon is a professor of law at the University of Windsor, has written extensively in the area of free speech and freedom of expression and hate speech as well as that. He has many publications. Another one that's going to be coming out fairly shortly in that area. He's also been recognized for many teaching awards in his own university as well. So welcome, Richard, to the panel. Linda McKay-Panos is the Executive Director of Alberta Civil Liberties and has a degree in education, has law degrees as well, and has been working extensively in the area of research in the area of free speech and hate speech in Alberta and elsewhere. She has been awarded and recognized for her accomplishments and achievements. She is the 2001 Suzanne Maw Award winner. She has also received the Alberta Centenary Medal in 2005 for her work as well. And finally, we return to Ola Malik. Ola is currently a municipal prosecutor for the city of Calgary. His educational background is extensive and primarily in Europe. And has written extensively in this area of public protests and the relationship of public protests and how that works its way through public prosecutions in Canada and through Canadian courts. Has chaired several different committees and is well recognized in terms of publications, and also has done several notable public prosecutions that have received national attention across Canada. So with that, I would ask you to look at each individual member's biographies. That will give you a good sense of their background. And then let's just start up. Let's begin our discussion in terms of that. So if you'll, we'll get things going. As you know, the topic of today's discussion is the whole notion of the relationship between freedom of speech and when does it become a hate crime. The two guiding documents here are the Criminal Code of Canada, which have several sections 318, 319, that regulate issues of what constitutes advocating genocide and what also constitutes, broadly speaking, hate speech, and then also Section 2 of the Canadian Charter on Rights and Freedoms, which asserts that we all have the freedom of expression, thought, and belief, and those things. So with that creates tensions, and those tensions have to be played out within society. So each of our panelists are going to spend about 15 minutes talking a little bit about their take on the issue, and then we'll open it up for comments and questions from the floor. So with that, I'll turn it over to Richard. Richard will be the first to go, and we'll go from there. All right, thank you.
Well, thank you for coming, and I wanted to thank the organizers for including me in this event. It's lovely to have the opportunity to come to Calgary, and I've really enjoyed my time here. Well, 15 minutes is woefully inadequate to speak about such a topic, and I hope that I won't be able to say all I'd like to say, but I hope that perhaps during question period it'll be possible to develop and elaborate upon some of these things, and I'm sure my co-panelists will have many things to add to what I'm saying. Now, first let me say that hate speech is regulated in Canada in two different ways, really. And as the moderator indicated, it's restricted under the Criminal Code of Canada. There are a number of provisions that relate to hate speech, but probably the most important is the prohibition on the willful promotion of hatred against identifiable groups. And some of these grounds are listed, of course, in the Criminal Code. The other principal way, legally, in which hate speech is regulated in Canada is through human rights codes. Section 13 of the Canada Human Rights Act, until its repeal about a year ago, limited internet communication that was likely to expose the members of an identifiable group to hatred or contempt. But as I say, that provision was repealed about a year ago. But there are several of the provincial human rights codes continue to include such a provision. The code of this province, Saskatchewan, Manitoba, no, not Manitoba any longer, excuse me, Saskatchewan, Alberta, British Columbia, and the Northwest Territories each include a provision similar to that of the now repealed Section 13, although they apply not to internet communication, but rather to publication signs and so forth. Now, these two forms of regulation are quite different. The criminal code, obviously, and criminal prohibition obviously involves a very different process in which we're talking about police investigation, ordinarily criminal prosecution, and a punitive remedy if one is found to have breached this provision. In contrast, human rights code provisions are understood or designed not to be punitive in character, but rather to prevent a particular undesirable or harmful activity. And the principal remedy, if someone is found to have breached the Human Rights Code provision, is an injunction to cease and desist from the particular damaging activity. Now, what they both have in common is that the speech that is subject to restriction is said to be extreme in character, to be hateful in character, speech that is likely to stir up hatred in the community. And what the courts have said this means, really, is speech that is so extreme it can be associated with vilification, deep detestation of the members of a particular group. Now, these bans, of course, are controversial. That's one reason why we're here and talking about them, and there is certainly a challenge in seeking to reconcile the restriction of hate speech with a public and indeed constitutional commitment to freedom of expression. Freedom of expression, of course, protects the individual's rights to express his or her views. It protects the right of a potential audience to hear what others might have to say to it. The audience must be allowed to hear different claims and make its own judgment. That's really what freedom of expression is about. And indeed, one of the underlying assumptions of freedom of expression is that if the members of an audience take action in response to words they hear, and that action, of course, can be because they agree with what's said, or it can be because they deeply oppose what's said. But if an audience takes action, the assumption underlying our commitment to freedom of expression is that the audience, those who take that action, are responsible for the action they take. The speaker is not responsible for the action that's taken. The speech is not understood as causing the action in any way, simply because it may persuade the members of an audience of a particular view. Now, underlying this idea, this commitment to freedom of expression, are a couple of basic premises. One of the premises is that audience members, individuals, are substantially rational beings who are capable of evaluating facts, of making judgments, and so forth. The second assumption, of course, is that public discussion is open to a wide range of views. So if something is said that may be incorrect or misleading or offensive, there are other views out there that may contradict or correct what is said. The claim often made is that the answer to bad speech, in quotation marks, is more and better speech. And that's really a critical idea behind our commitment to freedom of expression. More views are better. Now, we recognize, however, that these assumptions that underlie freedom of expression don't always hold. And sometimes we're concerned about speech that may incite people or speech that may manipulate the audience in some fashion. And one need only think of a couple of very famous examples of either manipulation or incitement to try to understand this a little bit better. John Stuart Mill, famous English philosopher and defender of free speech, gave as an example of speech that could be restricted, a speech, now this tells us the historical period we're speaking of, a speech given by an individual outside of the home of the corn merchant, a fiery speech given to farmers, who might then be incited to take action. And I think the idea is that in such a situation where emotions are high, where the circumstance is immediate, that we might see the speaker not simply as aiming to persuade the audience of a particular view and even of desirable action, but actually, in some sense, as leading the audience, as leading the group of farmers to take certain action. And that's usually what we mean when we talk about incitement, that there is so little space for reflection, for judgment, and emotions are running so high that we worry about immediate action being taken. Now, the other famous example comes from a judgment of the famous American judge, Justice Holmes. And I'm sure most of you have heard this example when he said free speech is protected, but not the false yell of fire in the crowded theater. And in that circumstance, of course, we recognize that, again, individuals are going to act quickly, impulsively in response to a statement or assertion of that kind, and injury or harm may result. And maybe the label manipulation, a difficult term, may be applicable in that sort of situation because we recognize that individuals in the audience, in the theater, are not in a position to stop, think, assess the claim, make a judgment about, is there really a fire in this theater? And how should I respond or act if there is or is not? They will act quickly and impulsively, and injury or harm may occur. So I think we recognize, and free speech doctrine has always recognized there are times and places where the space for careful, thoughtful reflection is limited because either emotions are running high or simply because the circumstance, the context is such there is just little opportunity to think and reflect about the claim made. Now, free speech doctrine has recognized a number of limits on expression. So we seem to accept that it's legitimate for the state to restrict false advertising for a range of reasons. Because again, we recognize that in the so-called marketplace of ideas and information, that large corporate advertisers have a disproportionate amount of power and influence, that advertising is often not geared towards seeking to persuade individuals through argument and idea, and it's really individuals who might want to correct those false claims in advertising have a very limited ability and opportunity to do so. So we think it's acceptable, I think, generally, to limit and restrict misleading or false advertising. Similarly, we have laws against defamation, libel, slander, and so forth. Again, because we recognize the significant harm that false claims about an individual can do to that individual's reputation. And we recognize that corrective speech may not always work very well because the audience's ability to assess or determine whether a claim made about an individual's reputation is true or false may be limited. And secondly, human nature being as it is, a true claim about somebody being a perfectly decent, honorable person tends not to circulate quite as effectively as a false claim about how truly terrible and awful they are. Now, I say all this just as a basic recognition that, of course, we recognize that there are important grounds to restrict speech in a variety of situations. So the question really is, well, what about hate speech? And let me say that I think that our courts certainly have been willing to accept that the harm and injury of hate speech, of extreme speech that seeks to vilify the members of a particular group based on race, religion, ethnicity, and so forth, can cause enormous damage in the community, can create a variety of risks either a direct harm by insulting or intimidating the members of a particular racial or religious group, or indirectly by persuading the members of a more general audience that the members of a racial or other group are dangerous or undesirable and should be treated accordingly. Now, at the core of hate speech is a claim that is false, a claim that either denies the equal worth or value of some individuals based on their race or other group membership, or, and more often, the false attribution of a dangerous or undesirable trait to the members of such a group, a claim that the members of the group are violent or dishonest or some other undesirable characteristic. The false claim may be viewed as hate speech when it is extreme in content and tone, when it vilifies the group or seeks to stir up hatred or fear of the group. In other words, when it's so extreme that it may be seen as justifying violent action against the members of the group. Now, the form hate speech takes often, the circumstances in which it often occurs certainly strengthen the case for its restriction. It often makes a very irrational, visceral appeal to its audience that may be understood as discouraging careful, dispassionate assessment of its claims. The claim that a particular group represents a threat, a danger to society and the well-being of others, particularly when expressed with great anger, is more likely to stir anger and fear in the audience and discourage careful reflection. An audience may be less critical of hateful speech because it provides a channel for fear and resentment in some way, of moral decay or terrorism or economic or social failure. And of course, it can also be more dangerous and more effective because extreme speech builds on more general stereotypes and racial assumptions that circulate throughout a society, less extreme claims. Finally, and I think quite significantly, hate speech, it's important to note that hate speech generally occurs at the margins of public discourse. And I'm talking here not about stereotypes, which of course are everywhere around us, but the kind of extreme speech we're talking about when we talk about hate speech. It's often directed at the members of a racist subculture who are not very interested in exposing themselves to other views and certainly not to corrective views. And when it's directed at such an audience, extreme speech may reinforce, extend bigoted views without being subjected to public criticism. And certainly today, the internet has become the principal vehicle for the expression of hate speech. And we know, we've come increasingly to realize the internet audience is highly fragmented. It's easy for a particular website to operate at the margins and to avoid critical public scrutiny, in effect, to operate under the radar. A number of years ago, I was asked to write a report on internet hate speech for the Canadian Human Rights Commission, and until I did that, I was really unaware of the number of hate speech sites that existed out there, and was pretty horrified when I discovered how many there were and how effectively they sometimes operated within their narrow subculture. So, given these sites can often be a very effective means for individuals or groups who hold hateful views to encourage others to adopt more extreme views or to take violent action without, again, being exposed to critical alternative positions. The argument in support of hate speech regulation then must go something like this. Despite our commitment to freedom of expression, we know that human reason does not always operate, particularly in some times and places. The failure to ban the extreme or radical edge of prejudiced speech, speech that is extreme in content, justifying either explicitly or implicitly violent action against the members of a particular group, and that is visceral or irrational in its appeal, carries too many risks, particularly when it circulates within a racist subculture that operates at the margins of public discourse. How am I for time? 1 minute? 2? Okay. Well, I thought I would not be able to say any more, so let me say a couple of things then that I wasn't sure I'd be able to say. So one of the things I wanted to say is very often when people talk about the harm of hate speech, they emphasize the notion of hateful views spreading throughout society, a kind of a recreation of Nazi Germany or something like that. And I think obviously we need to be concerned about the spread of hate throughout the community. But I think we shouldn't lose sight that maybe the most significant objective hate speech prohibitions ought not to be that, but ought to be concern about the encouragement of individuals, small groups of individuals, to take increasingly extreme action. We should be worried about the encouragement to take acts like gay bashing or or seeking to burn down a mosque or whatever it might be. We shouldn't simply worry about widespread hatred. We need to worry about isolated, so-called, I'll put them in quotation marks, isolated acts of violence within our community that is racist in character. The other thing I wanted to say very quickly, and then I will finish, is that it's also important to recognize that we're focusing on extreme speech. Racist speech or racialized speech that, or thinking and speech that about issues of race is widespread. Stereotyping is widespread within our community. But as a practical matter, it is unimaginable that one could, through law, seek to erase any kind of racial speech, racial thinking, particularly as I might describe in the form of stereotyping of different kinds. The emphasis, the focus of legal regulation has to remain on extreme speech. There are a variety of reasons why it's simply impractical. Any attempt to exclude from public discourse speech that stereotypes or defames the members of an identifiable group would require extraordinary intervention by the state and would certainly dramatically compromise the public commitment to freedom of expression. Because these less extreme forms of discriminatory speech are so pervasive, it really is vital that they be addressed and confronted rather than censored. We've got to develop ways other than censorship to respond to expression that stereotypes or defames the members of an identifiable group. And the view I've taken in the past is that there is an important place in the criminal code for hate speech regulation. I am less convinced that human rights code and the human rights code process is the appropriate way to deal with hate speech for a variety of reasons. I think the code itself, which is geared towards seeking to prevent discrimination broadly understood in a very, very broad sense, and establishes a process that's intended to deal with discrimination in that broad way, is not an appropriate forum, an appropriate process for dealing with extreme hate speech. And one way I might put that, and there are many ways to put it, is to say human rights codes are geared towards education and reconciliation and so forth. The idea of a mediated resolution between a neo-Nazi and a victim of his or her odious speech just doesn't make a lot of sense to imagine the two sitting down together and working out a happy compromise around their misunderstanding. So thank you for your time.
Thank you, Richard. Our next speaker is Linda. Linda is going to talk a little bit from the perspective of civil liberties and that approach to the topic. So I'll turn it over to Linda then.
Hi, thank you very much. And thank you to the organizers for inviting me here today to speak. So I'm going to approach this just a little bit differently than Richard did. I'm going to start with talking about the value of freedom of expression, because that's so very fundamental to our democracy in Canada. And it's been protected over time through our common law and our bills of rights, and even some of our human rights legislation mention freedom of expression. And of course, once we passed the Charter of Rights and Freedoms, we made it one of our fundamental guarantees of freedom of expression. And you should know that freedom of expression is also recognized internationally in the Universal Declaration of Human Rights. So this is a universal recognition of the fundamental importance of freedom of expression. And Canadian law, the judges whose job it is of Supreme Court to interpret the Charter have interpreted expression as anything that attempts to convey a meaning. So as soon as something attempts to convey a meaning, whether it be a picture or words or even sometimes behavior. So if I'm protesting the fact that somebody always uses my parking spot and I don't know, block it with my car, that may be a freedom of expression, and a behavior, okay? And so in general, those are protected. So they have very broad protection in Canada, and that's because the limitations on freedom of expression are found in Section 1 of the Charter, unlike in the US where they limit the freedom of expression when they're trying to define whether it is a freedom. We look at whether or not we should justifiably limit somebody's freedom of expression. So what we have in Canada then is a recognition of three kinds of expression that are what's called the core of freedom of expression. And those things are very hard to limit. And then when you get outside of the core, it's easier for the government to justify limiting those kinds of speech. So the kinds of speech that are in the core include political expression. It's one of the cores. The idea that we can exercise our right to vote knowing what we're doing, that we can freely explore political ideas, and by the way, that's not the case in a lot of other countries. And those who speak out against the government, that's important too. And also minority groups. This is their chance to speak about their position on things and identify things that need to be changed in society. So freedom of expression is a very important, and political speech is part of our core. Other parts of our core protected freedom of expression include personal self-fulfillment, personal aspirations, and again, this would include the ability of minority groups to pursue equality and make sure that they feel that they can express where they're not experiencing equal treatment in our society. And finally, the other part of the core is the truth, and that's where John Stuart Mill, whom Richard referred to, falls in. This whole notion that if everybody's allowed the freedom of expression, even if sometimes they don't get it right, if we exchange ideas freely, we're going to hopefully arrive at the truth. And that's the sort of philosophy behind truth being part of the core. And again, one of the defenses under the criminal code is if what you speak is the truth, that's a defense to being found guilty of hate speech. So we have this democratic, philosophical, and personal core protection to our freedom of speech, but there are limits. And if, for example, as Richard mentioned, harm is one of the limits, and so, for example, two kinds of speech are not protected at all. One of them is violence or speech advocating violence. That has been held by the Supreme Court of Canada not to be part of the guarantee of freedom of expression at all. So in other words, if somebody's advocating violence, that would not be considered something that would be protected and would not even be, it would be illegal and not protected. But you couldn't say, oh, I have my freedom of expression. Where you run into a finer line is the kind of speech where the government can justify limiting it using Section 1. Hate speech falls into that category, as does commercial expression and pornography, obscenity, those kinds of expressions. You have to have a reasonable and justifiable reason for limiting speech. And the court will be more sympathetic if you have legislation such as a section of the criminal code or our human rights legislation in some cases that has punishment for hate speech. So what you get then is a recognition of the fundamental importance of freedom of expression, but also a recognition at some time we may have to draw a line. The question is, when do we draw the line and how do we draw the line? And one of the two of the ways that hate speech is limited in Canada is, as been mentioned already, in some of the human rights codes, formerly in the Canadian Human Rights Act, and also in the criminal code. Why do we have these limits? Well, because we do have commitment in this country to fostering equality, multiculturalism. The protection of minorities is a very fundamental value in Canada, and that therefore, and sections 15 and 27 of the Charter actually embody some of those principles. And so basically the goal in passing laws and interpreting them is to strike a balance between preserving these essential core types of speech and at the same time limiting the peripheral outside of the core, right? So do the hate speech laws work to do that? There have been criticisms on both ends. So there are those who think the criminal code provisions are too loose. They're not strong enough. They don't cover enough minorities. In fact, they wish that you didn't have to say that you fell into an identifiable group. It would be enough if you were a victim of hate speech. There are also those who criticize the defenses for that same reason. There are too many defenses. On the other hand, people say a classic civil libertarian criticism of the criminal law is that you give the odious, rather, marginalized speaker a platform. So we had a case in Alberta, a Keekster case. Some of you might remember that case. And this dude, he was a school teacher, and he was making his students write on their exams that, bad things about Jewish people and that the Holocaust didn't happen and so on. And he did that for 12 years before a parent finally challenged him. And he was charged under the criminal code. Well, what followed was a series of court hearings that got tons of publicity for these views, and he produced experts in the court to say the Holocaust was overblown, and so he got a huge platform, a national, long-standing platform for these odious views. And arguably, civil libertarians would object to that because they would say it should be relegated to the margins and, or answered with freedom of expression to displace what this person has said. Also, they felt that the best solution, which did happen, was that the man should have been fired from his teaching job. And I agree with that because, of course, I used to be a school teacher, and I found that absolutely abhorrent, what he was doing. And you flunked if you didn't put that on the exam. That just boiled my blood. So, how am I doing? 2 minutes? My goodness, time goes by fast. As for the criticisms of the Human Rights Acts as they are currently worded, they usually have two provisions, one that deals with hate speech, and it's been very strictly defined. And the Supreme Court has said, as long as you keep it to really awful, hateful enmity, and not just making someone feel uncomfortable, that is sufficiently restrictive. However, there's also a secondary provision in the same sections of many of the codes dealing with has an intent and tends to discriminate, which is much more along the lines of the stereotyping that you were mentioning earlier. And so first of all, one of the criticisms then is that second part needs to be gone completely. And the other criticism is that it's inappropriate because it addresses a crime, and criminal law is the auspices of the federal government, not provincial governments, and therefore should be dealt with under the criminal code. Those have been the main ideals. So the American approach to civil freedom of expression is to pretty much permit everything and allow people to sort of exercise their own marketplace of ideas. We haven't gone that far, nor has Europe. We tend to be somewhere a little more cognizant. And my views, personal views, which are really neither here nor there, wax and wane. I think the thing that has persuaded me the most, because I was very persuaded by the civil liberties argument that the best thing to do, and I have tried this with the anti-abortion seminar displays at the university, is to exercise your own freedom of expression, either freedom from expression, don't look at it, or to try to have a little chat with the young ladies who are presenting the material, which didn't get me very far, but it sure made me feel good. So what has persuaded me to maybe soften my opinion is I have done a lot of work with racialized and sexual identity minorities, and they argue that this kind of speech makes them feel less. It's harmful to them, makes them feel that they can't participate equally in our democracy. And if that's the case, I'm prepared to admit that there will be some circumstances where we must limit, because we want everyone to be equal in our country and to feel that they are valued and equal citizens. And if we need to limit certain kinds of speech to do that, I'm prepared to look at that. So I think that's a good place to stop.
Great, thank you, Linda. Well, Malik is our last presenter. To remind you, we'll be taking questions from the floor after Ola's done, so start thinking of your questions and we'll facilitate that process very shortly. So thank you very much.
Hello. Well, the pleasure for me of appearing behind people like Richard Moon and Linda McKay-Panos is that they get to do the heavy lifting. They're the smart ones on this panel, and so I just get to follow up on some themes and some ideas that arise. It's a real pleasure to be here, and thank you for the organizers for the invitation. When we talk about freedom of expression, and when I've been in court and I've had some of these cases, the first question I always ask is, what kind of society do we want to live in? Because these are not just abstract ideas. We're not talking about the limits to freedom of expression, what that means in a vacuum. How we express ourselves, how we relate to our neighbor, how we treat our neighbor has real practical implications. These aren't legal issues or legal tests that some judge devised in a room on a hill, or they shouldn't be. We should be prepared to challenge, to push the boundaries of what we understand limits of freedom of expression to be. We should ask of our judges, of our judiciary, of our legal profession, we should ask, do these rules make sense? Are they practical? And are they promoting a society that we think we want to live in? And I want to touch a point that both Richard and Linda talked about, and that is, why is the right to freedom of expression so jealously guarded? I would argue it's one of the most protected rights and freedoms that Canadians have. Very, very difficult to argue that unless you're engaged in hate speech, that your activity doesn't constitute some form of expression. So there's a great example, which is that if you disagree with the parking law and you park on the wrong side of the street in the wrong direction, that could very well qualify as expressive activity. So the question is, what isn't covered by that? And the reason we so jealously guard our ability to express ourselves is because, as Linda talked about, the core values that encompasses. So the idea that we want Canadians to engage in our civic culture, to have a conversation, the idea that the exchange of views, the expression of our ideas and opinions fosters a greater understanding. It allows us some personal self-fulfillment. It allows us to go through this world in a way where we're interacting with our neighbors in a real way. And so the question then that leaves me with is, have we been too expansive in simply saying that anything that constitutes expressive activity, unless it meets the very high threshold of what hateful speech is it too expansive? Are we allowing speech which is detrimental, which is harmful, which is very offensive to some people, to some groups, even though it doesn't rise to the level of hate speech? Because hate speech is a very high test to meet. The fact that I say something that's offensive, or that may be hurtful, or that may buy into or reinforce a stereotype, is probably likely not going to constitute hate speech. Hate speech is something, as Richard talked about, it really singles out a vulnerable or marginalized group to detestation and vilification. In a way, it removes them from the civic conversation. It makes them feel like they're just not part of our society at all. But the problem for me on a practical level is that there's a whole bunch of speech which is just as pernicious, just as pervasive, but we're really struggling with what to do with that. Because from a practical aspect, when I go back to the first question which I asked, which is what kind of a society do we live in, we as Canadians, judges don't come from Mars. They come from all of us. They live our experiences, they go to law school, they serve in a career, and they become judges. And so the question is, when I walk down the street and I see advertising or I see expression which is very offensive, which engenders a stereotype, is that okay? Now, it may not be included in hate speech, but is there something that we should do about it? And I think Richard's quite right to point out that there are practical challenges of regulating speech that may fall short of what constitutes hate speech. I was watching a movie the other day, I think it was Zoolander 2, and in the trailer there's a reference, I think, to retarded people. And I have to tell you, I found that to be offensive. The anti-abortion debate in Calgary has really, I think, caught fire over the last couple of years with the activists that we see. Is referring someone who is pro-choice as a baby killer, is that the way that we want to engender our conversation? Stereotypes especially, notwithstanding the generational shift that we've seen on gay marriage, there are still stereotypes about gay people, transgendered people that are pernicious. And when you look at young people who are struggling with those issues, those stereotypes in many ways and in many cases are fatal. So the question that I have is, what kind of a society do we want to live in? Is it okay to say, from a legal perspective, a judicial perspective, that only speech which is so extreme is speech that we ought to outlaw? Or should we start thinking about how we regulate conversations in a world that is becoming much more urbane and much more global? And of course, the irony about that is that when you look at a city like Calgary, I grew up in Calgary, you have ethnic communities in Calgary now that you didn't have 20, 30 years ago. And so you would think that would engender much more tolerance, diversity, and pluralism and understanding. And I think there may be some of that, but I think you're also seeing the other side of that knife, where you're seeing really difficult and dangerous stereotypes. And my concern is that the effect of that is just as damaging as hate speech. when you hear a stereotype day in and day out, whether it be, someone was telling me about some cartoons of Jews, and it was a typical cartoon of a Jewish fellow with big teeth eating a Lebanese baby. I mean, these are pernicious stereotypes. I would argue that probably does amount to hate speech, but you can think of images or depictions or expression which really would cause the reader to come to the same conclusion, or it may raise the same image in the reader's mind. And I'm not sure that exposure to that over years wouldn't cause someone to come to the same conclusions or support the same views as a message which is truly hateful. And we don't have Ku Klux Klan marches anymore. You know, we don't have the kind of in-your-face demonstrations of hate that we may have had 40, 50 years ago. You know, the civil rights movement is over. I think that messaging now is much more intelligent. It's much more subtle. I think people know how to communicate to the audience. I think audiences are much more sophisticated. They understand what to look for. And my concern is that in this community, I mean, my view is that we should treat our neighbor with some respect. We want to include people in the conversation. And whether as a result of stereotypical images or true hate speech, I don't think it's acceptable for anyone to feel excluded from that conversation. We don't want any of our citizens, certainly in the city, to feel like they can't participate in a debate, to feel like when they come to that table, they're already having to overcome a very steep mountain of prejudice and stereotype. That is not empowering. And I think it takes me again to the first question, which is it may very well be right now that we've drawn a very clear distinction between what constitutes hate speech, which is not allowed, and which constitutes non-hateful speech, which is. But I think my challenge, and I think my certainly one of the things that I think about when I argue these cases and when I write is there any way in which we should be thinking about that kind of division differently? Should we be living in a different society? What ought we to be expecting of our judges, and what ought we to be expecting of our neighbor? And so perhaps my presentation this afternoon wasn't as formalistic as that of Linda and Richard. I do think of these issues thematically, and I deal with them in a practical way. So perhaps a little bit of a different presentation. I suspect I'm pretty close, so I want to thank you for this opportunity. Thank you.
So we've heard some really interesting, thought-provoking ideas. I have 15 questions, but it's not my opportunity. I'll ask those questions later. So we invite members of the audience who have questions to acknowledge where you are. We will ask you to, if you wouldn't mind, introduce yourself. Just a first name would be fine. And we have a microphone that we'll ask you to use so we can project to the entire audience. And we'll just go back and forth as we go through. So if you wouldn't mind just raising your hand, and someone will come with a microphone to you. So gentleman over here actually was the one. I'm going to have to go on the who I can see first, and then we'll go from there. So make sure you wave your hand, because it's difficult to see at the back. So let's go from there, and we'll just open it up to our panelists, and they can decide who wants to answer it.
How should we deal with religious textbooks or religious books that violate our hate speech laws? Should we grandfather them, or should we put warning labels on them like they do on cigarettes, or do we just ban them outright?
Well, I guess in some sense your question has answered its own question. If the texts actually constitute hate speech and breach hate speech laws, then I guess they ought to be prohibited and banned and removed from schools, regardless. But that I guess leaves open the larger question is always what counts as hate speech, and how do we make the determination that something in a book like that might amount to hate speech? Now, one thing that I do think is worth, and I'll just use this as an opportunity, is so Ola was talking about really standards of civility and respect that are vital within any kind of society. And for the most part, I think Linda and I were talking about hate speech regulation as it applies in a very general sense to kind of open discourse. But most assuredly, we established different standards of respect or civility in various locations. So in the workplace, for example, we have different rules and standards of respect and civility that are far They're very different from simply the extreme hate speech. Or in the school classroom or the university environment, we have different expectations of civility in those kinds of closed hierarchical environments where an individual cannot easily escape or evade kind of repetitive, insulting, stereotypical speech. So I think it's important. I say this only because you mentioned the school and the school classroom. If we're talking about schools and teaching children, then of course we should have very different standards of respect, non-discrimination, than the extreme, exceptional standards of the criminal code.
Okay. I think over here next, if you don't mind, then we'll have two here.
Thank you. I'd like to actually just pick up on something that you just said about sort of generalized speech and how it relates to social media, and specifically Twitter, which is such an interesting medium in terms of people who might be perfectly nice when you meet them face to face, but who take the gloves off, having some anonymity. So in terms of regulating social media, how does all of this apply?
Can you hear?
Yes.
Yeah, Give the practical question to the guy who has absolutely no idea how to answer the question. There is, and I have to tell you, I haven't prosecuted that because I do municipal prosecutions. Haven't prosecuted. It's a very good question. I think there's a challenge. There's just a practical challenge in prosecuting people who transmit these kind of messages via Twitter or social media. It's just much more difficult to. To track down. I have to tell you, I don't know what the answer to that question is. I'm struggling with it.
Yeah, well,
I'm going to tell you a little bit more, if that's okay.
Please.
Just a bit of detail. Ezra Levant, who I'm sure you all know, who's been with this, so he made a comment this morning that much skewed a comment somebody had made to him. He claimed that this person was telling him to go back to his own country, and what the person actually said was, maybe you should just leave. Equally not nice. Anyway, so I commented to say, Ezra, you're misrepresenting that comment. And somebody else came after me and ad hominem, like the guy wrote the book on ad hominem, and I'm like, why did you go? Anyway, so where something like that happens, me as the person who's now being attacked could a person ever go to the Human Rights Commission and say, this person did this to me in public?
Well, yeah. I mean, one of the difficulties, of course, is policing any of this. And I think one thing I didn't say is that there really are very few prosecutions under the criminal code first, but even complaints made with regard to hate speech under human rights code. Very exceptional. And under the criminal code, even when there is a prosecution, I should actually add, a prosecution cannot be brought under the criminal code without the consent of the Attorney General of the particular province. So there's another major hoop, and attorneys generals often been reluctant to give consent for a variety of reasons. But even when a prosecution is pursued, often not successful. So we can talk about these laws, and they certainly play an important symbolic role within our community, but they are often not enforced. So policing is a challenge. The other thing is, of course, we have to be talking about hate speech. We have to be talking about speech that is targeted, not at an individual, not insulting or hurtful or whatever. It has to be based on race, their membership in a particular group, race, religious, or otherwise. I guess we're in the, notionally the home territory of the individual you refer to. I will say, I'm sure that almost everybody, on this panel has in some way been referred to an individual who I discovered, is, fast and loose with the truth is just doesn't even capture it. The funniest thing, I had never met Mr. Levant at all, but I wrote something that he took issue with. And my favorite bit was, there are many, many things that he wrote were quite objectionable and false. But my favorite bit was actually the very personal bit, because it was so irrelevant. He described me as a 60-something professor in the winter of my career. Well, that was about 6 or 7 years ago, and I still am not 60. And I thought, had he met me, I might have been deeply hurt, by this. But the fact he had never met me, so he just made it up, as is the case. He just makes stuff up as convenient at any moment. And I think, you know, the one thing you should take comfort is I think everybody knows that at this point, that it's just all invented out of nothing.
Recently, a woman in an airplane was sitting by a gentleman, and the gentleman said he could not sit by a woman because it was against his religious freedom of religious expression, that he not be allowed to sit by a woman. Now, I'm wondering about the woman's freedom of expression to sit where she had purchased this seat. And, you know, women can be seen as having had discrimination in the past, so as a group, not just an individual.
Is this on?
There we go.
Oh boy, technically inadequate. So what you're talking about there is more of an accommodation question. So you've got one person who has, you know, purchased a seat and has every right to sit in the seat they have purchased. Another person who has some problems personally. So the question is, can that religious belief be accommodated to the point of undue hardship? So one of the options would be to ask the gentleman to move him somewhere else in the plane. But I wouldn't expect that it would be appropriate to ask her to move, because she's not the one asking for the accommodation. She's paid for that seat, and I would say that in that case, then it would only be if they had another seat, if they were able to move him, because they do have the opportunity to defend their actions if they couldn't move him, if it was an undue hardship. They'd say, for example, there weren't any free seats, or there was nobody willing to trade seats with him, or whatever.
You've raised an interesting issue, and maybe it doesn't raise hate speech, but it's an issue that I think about. We focus a lot on what rights we have to express our views. We're not so ready to talk about what rights we have not to be exposed to those views. So there's a corollary there. They're just two sides of the coin. And there's a doctrine in the States called the captive audience doctrine, which says that in some circumstances, I can decide, I have a right as the listener of an unwanted message not to be exposed to that message. And in a way, that's the corollary to my right to say what it is that I want. But those rights have to operate in tandem. So it's interesting. You have two people sitting beside each other, and one of them is expressing messages that are unwanted. The question is, does the person who's being exposed to this message, do they also have a right not to have to sit there and kind of deal with it? So it's, when you talk about the two people sitting side by side, it raises really interesting issues about what are the limits. We talk a lot about the right of the speaker to speak. We don't always focus so much on the right of the listener not to have to listen.
Please.
Yeah, again, not so much a hate speech issue, but the example you give does really highlight some of the challenges around the idea of religious accommodation. And the way I sometimes think about it is that when we think about accommodating religious practices, we recognize that religions and religious beliefs and practices can be understood through two lenses. We can understand religious practice as just a practice that is part of a tradition of a particular religion. The practice of a community or their beliefs are part of a community identity in some way. But we also recognize that religious beliefs involve views, values about the way the world should be, about the rights and interests of others, of how we should behave in the world, and so forth. And so when you have something like the requested accommodation in that case, if you see the individuals, if you see what's at stake as just an individual practice, like there's certain foods I can or can't eat, or there are certain ways I should or should not dress. If we just see it as the way a community identifies itself, lives in accordance with its understanding of God's law or divine requirements, then accommodation makes perfect sense. It seems, okay, if we can accommodate that without it being particularly costly to others, that seems reasonable and fair. On the other hand, if we see the particular value or practice as reflecting something that about the character, rights, or interests of others in the community, then, and in this particular case, we see it as potentially a view about women, the role of women, the cleanliness of women, or whatever it might be, then the idea of accommodation seems not quite so demanding or appealing. And I think that's one of the challenges with religious accommodation, because we can always see practices through these two different lenses. And our response to it perhaps depends on which lens we view it through.
Good afternoon. My name's David Bertram, and I'm from Calgary. You brought up Ezra Levant before, an individual who's come before the Alberta Human Rights Commission, one who's being challenged now by the Law Society for his journalistic views, one who happened to be taught by my sister as a debate coach, so I know a lot about the history. I'm going to ask a question from the political arena, not so much about hate speech, but we find ourselves now in the midst of a federal election, just coming out of a provincial election. We're entitled to speech in this country until an election is called, and then we have third-party advertising restraints. Your views on, and we go back to Tuesday's discussion, temporary foreign workers that was discussed here. If someone wanted to bring that forward, talk about it nationally, they'd be limited to $2,500 during a campaign. What are your views on limiting speech during a political campaign? The parties can speak, the candidates can speak, but everyone else can door knock and listen, but no one else can take out advertising or speech. This can be heard by others.
Well, I mean, the first thing I should say is that third-party limits apply only in situations where the speech is understood as supporting or affirming the position of a particular party. So a third party, and when I say third, it's a little confusing to use the language third party when we're talking about party politics, but a non-party, non-candidate, someone who is not a direct participant in the election itself as candidate or party, can participate in and can spend unlimited amounts of money to raise an issue that they believe, for example, is not being addressed by either the parties or candidates. It's only if the speech is understood as supporting a position taken by one of the parties or explicitly supporting the party. Now, with that said, I do think there is a place for a limit on spending. Spending by candidates and parties. And if you're going to have limits on candidates and parties, then in a sense you also have to limit on those who are not parties, because otherwise you'll get what goes on in the United States, where the candidate doesn't speak, but you have an organization or association that is loosely connected or affiliated with the candidate or party that can spend oodles of money to advance the particular position of that party or advertise explicitly in support of that party. And, you know, sadly, it should be the case that more speech makes no difference. But we know that in the kind of world of communication today, in particular electoral politics, where it is not about so much providing information and thoughtful reflection about policy and position, but it's very much about building image, candidates, very much a visceral appeal, it appears that more advertising, more money makes a difference. So we have to find ways to limit that. And if we limit it for candidate and parties, then we've got to limit it for third parties, particularly when they're weighing in explicitly in support for a particular candidate or party. So that would be my position. I mean, there's a lot more to be said about that, but.
We have two hands over here. Gentleman first here, and then immediately behind him.
My name is Gerard. I really have three questions. First, how is online freedom of speech of a marginalized teenager protected from being used as hate speech that may damage him or her later in life? Second question is, how does the freedom of opinion impact the freedom of speech? And final question, why does it appear that Bill C-51 seemed to erode the freedom of expression?
Could you state the first one first, please?
Just a little slower.
Yeah.
How is online freedom of speech of a marginalized teenager being protected and used as hate speech that could damage or hurt him in later life?
Are you speaking about the current situation with a young woman? So we have a person running for the Liberals who said some things a long time ago, and that's been brought up and used against the person, and they have subsequently. It was. You should go blow yourself away. That was one of them. Am I sort of on the right track? It's really interesting. We work with schools quite a bit at the Civil Liberties Center, and we do a lot on cyberbullying and on privacy and so on. And a lot of young people just do not understand that once they put something out there, that it can be up there for life and can be used against them by a future employer, or in this case, somebody dug up the dirt on this person, something they said as a young person, and it affected their career tremendously. And it's one of the realities of sort of a practical thing, that was definitely used. And we can all think of other examples of things that have been dug up on other celebrities and so on, either through the internet or otherwise, that have affected them tremendously. And especially once you become a public personality. And so it's really unfortunate. But I don't know how we're ever going. I don't think she's been charged with anything. I think it has just affected her ability to run in the election, which is most unfortunate. But I think that's one of the things that it needs to be taught to young people, and we're working on it. But it's if you recall when you were young, and I barely do myself, but. You don't think ahead very much, and it's something that you don't think, well, who cares what somebody thinks of me 10 years from now? I'm still going to post my naked picture, like horrifyingly, if you imagine in the future. So I think that's a big problem. I don't think she was charged with anything, so.
Would you allow us to go to other people and then return to you for the questions? Gentleman behind you. We'll get back to you.
Oh, sorry. Good afternoon. My name is Harry. Are we paying more attention to hate speech because of the growth of social media? For example, if I'm walking on the street, somebody is making a comment, I just keep going. But because I'm social media, I'm sitting in front of the computer for 2 hours, then I keep responding to all the hate speeches. So do we have to pay attention to all the social media hate speeches and then going to the court or sending responses? My question is it because of the social media it has become so big now, hate speech?
I think that's in part. I think the other thing is that advocacy groups are becoming much more sophisticated. They understand what the limits are. And I'll take the anti-abortion group, and you've seen their posters in downtown Calgary. They're very, very sophisticated. They have lawyers giving them advice, and they're prepared to walk up to the limits of what they understand the freedom of expression to be. They often have negotiations with civic partners or with the or levels of government. They will often, we have religious groups advertising, standing outside of transit facilities. There will often be, they know exactly what they're entitled to do. And they're generally very well funded, and they're very sophisticated, and they understand that notwithstanding that they're going to cause controversy, that's precisely what they want to do. And so I agree with you. I think it's in part social media. When I grew up, I mean, where did I get my information from? From the encyclopedia and a newspaper and books and kind of, television and radio. And so really the way in which someone, unless I knew someone who was involved in one of these advocacy groups, the chance was I was never going to hear what they were saying. Now, because it's so easy to communicate your views to such a broad range of people, I think we're just being exposed now to different points of view and different modes of expression than we would have when we were growing up.
Richard?
Yeah. I mean, I think this raises really something very important, interesting. I mean, one of the great things about the internet was, we thought, and it certainly is a valuable thing, is that it removed many of the filters that, often kept out a wide range of views. No longer, was it that major newspapers or media outlets could somehow control exactly the shape or scope of public discourse. But what goes hand in hand with the so-called democratization of discourse through new media has been, first of all, fragmentation, which is itself a problem. But secondly, any view somehow can be out there, no matter how irresponsible, how unfounded it might be. Now, the one other thing I wanted to say, though, just in connection with what you said at the beginning, is when we talk about hate speech, we're not talking about different kinds of speech exactly, but we're sometimes talking about two different kinds of harm. There's the harm that can be understood as directly experienced by the members of a target group, the kind of insult or more deeply the sense of threat or intimidation that can come. Think simply of a burning cross, planted on, somebody's property or whatever. I mean, a direct act of intimidation. Of course, we know what it means. It has a kind of rich and horrifying history, and we know the message behind it. So that sense of intimidation or threat that it's directly experienced by the members of a target group. But other times we're talking about something a little bit different, and that is speech that may never be heard by the members of a target group, but is directed at members of, the dominant community, whatever we frame it as. And it's really meant to persuade and encourage or reinforce dangerous or undesirable views about the members of a target group. And our fear is that especially speech that circulates on the internet through these sort of subcultures will embolden people, encourage them to take more radical or extreme action against the members of target groups. So there's a lot going on sometimes when we're talking about hate speech, and it's sometimes necessary to disentangle these different sorts of harms or injury.
My point is, like the personal attack through the social media, why shouldn't we be taken so seriously? Because, as I said, if I'm walking, somebody makes comments, I just keep walking to my work. I ignore that person completely. But in the internet, when you're sitting 1 hour, we keep responding, and then why should we take seriously all this? That's my point, and we shouldn't be taking seriously all the social media attack on personal attack. And as he said, Malik said, when it comes to inciting violence, that's what we should give more importance about the hate speech, because hate speech will always be there. This is a society is like that. But if we give importance to every hate speech and discussing about it going to the court, I don't know where it's going to end.
Okay. We're getting close to our time. I think we can take one or two more questions. So has anyone got a question that hasn't asked one yet? That is burning a question? Sorry? Oh, thank you. Yeah.
My name is Sharon Nagel. I've lived in Calgary my whole life. I was born here. The freedom of expression and the core value of truth is so important. We have so many people of different backgrounds coming to our country, which is wonderful, wonderful. But they come with different truths. And so how will our country deal with this if our education system doesn't start dealing with it at a very young age? The level of truths, the number of truths are so varied, coming from so many different countries. That's my question. Just about education, mostly.
I agree with you. And it's interesting in Quebec, the way that they've resolved some of that is by introducing an ethics course, and students are exposed to the beliefs of many different philosophies and religions. Now, there have been people who've not been too happy about that, because, of course, if you know anything about Quebec, it has certain religious aspects to it. But I think that educators are aware of the fact that we need to broaden our students' minds and teach them to be critical thinkers. And the way you do that, of course, is to expose them to as many views as you can and as young as you can, and give them the tools, including the tools to be critical of what they get on the internet. Yeah. And so I think it's being recognized, at least starting to be recognized, that we might be a little bit behind in Alberta, since we, parents are allowed to have their children excluded from certain conversations, but never mind, we'll catch up, and hopefully it'll be, more knowledge is power, and I think the key is the critical thinking that we need to teach. Yeah. To understand other people, I think what you're saying is, to understand other people, you need to know what they believe, what their culture says, and so on. Yeah, and I completely agree with that.
I think I would, and it's the problem of what truth and whose truth, but I think there's one universal truth, which is belief in the dignity of anyone. And what is so alarming to me, the way in which we now debate political issues, issues of controversies, we personalize attacks. It becomes vitriolic. And you can have a fundamental disagreement with someone over, let's say, the question of gay marriage, and yet fundamentally respect the choice that they've made, even though that's not a choice for you or for your family. I don't know why the two can't go hand in hand. The idea that you respect the dignity of people to make their own life choices in a way that they best know how without harming anybody else, even though you may really disagree with their point of view. But we've gotten so much smarter and so much dumber. The internet, media, the shrinking of the world has made us so much more sophisticated and smart, but it's made us so much dumber because we're not prepared to critically think about what assumptions we're making about other people.
I believe we've come to the end of our time, so I apologize to those of you I can't return to and go to initially. So first of all, I'd like to thank our panelists for their presentation. I thought there were some really thought-provoking ideas. If you'd allow me to return to the mindset that I bring to my life, and that's the life of a teacher. I suspect every one of you has learned something new today, or has thought about a topic in a way that you didn't think about before. Don't lose that. Write it down. I mean this. I truly mean this. Put it on paper. Put it somewhere. Return to it tomorrow to think about it again. The way that we push things forward in terms of perspectives and that is to not forget what we've learned. And it's too easy to forget things that we've learned. Some of us are going to go home, turn on CNN and be barraged by Donald Trump, and everything we've learned today is going to be gone. Write it down, put it somewhere, return to it tomorrow, and it'll stick with you a bit. So thank you for your attendance and participation.